Today is Monday, July 15th, 2013. We are at the Westin Gaslamp Quarter Hotel in San Diego, California. And we are here today to interview Judge Mary Schroeder in a brief video oral history to record some reflections on her career in the law. My name is Brad Williams, and I'm here on behalf of the 9th Judicial Circuit Historical Society. This interview will be preserved in the NJCH archives, and the Historical Society will provide you, Your Honor, with a copy for your own use. I understand that you were born in Boulder, Colorado.
That's correct.
And that you did your undergraduate work at Swarthmore.
That's correct.
How did you come to choose Swarthmore? That's quite a ways from Boulder, Colorado.
Well, I wasn't raised in Boulder, Colorado. My father and mother moved from Boulder, Colorado to Urbana, Illinois, because my father was on the faculty and moved from the faculty of the University of Colorado to the faculty of the University of Illinois. And Urbana, Illinois was a fairly small place in the middle of the prairie. And I wanted to go to a college that was near a great symphony orchestra. And I did not want to go to a big university because I had been raised in the environment of a huge university. So that's why I chose Swarthmore, because it was near Philadelphia, easy shot from New York, and the Philadelphia Orchestra had the greatest flutist in the world at that time.
And what was the flutist's name?
William Kincaid.
And did you play the flute?
I tried rather abominably for several years and then gave up. But I love the flute and I love great orchestras.
Interesting choice. Did you get many opportunities to get to see the Philharmonic?
Oh, I went to see the Philadelphia Orchestra every time that I could. They had rush seats for $5 and I'd be in the line. And I sang rather poorly in the chorus, and the great highlight of my musical career was to sing in the chorus of the Swarthmore, Haverford, Bryn Mawr chorus, joined chorus with the Philadelphia Orchestra on the stage of the Academy of Music, and there was William Kincaid. And I could see him from my stance at the top of the risers. It was a glorious moment for me.
Oh, wonderful.
That was when my musical career ended.
It ended on a high note.
It ended on a high note that I did not reach.
I see. While you were at Swarthmore, when did you decide you wanted to go to law school?
Well, when I was at Swarthmore, I got a grant for a summer to work in Washington doing research. And I followed around Senator Paul Douglas of Illinois, who was one of my heroes. And he offered me a job for the following summer. And so I learned a little bit about what was going on the Hill, and I realized that as a female, I sat in the office and answered letters of constituents, and the men who were interns went on to the floor of the Senate with the senator. This was commonplace all throughout the Hill for those few members of Congress who actually had female interns. So most of them were male. So I decided that if I was ever to do anything in public service or in government or in private industry for that matter, I had to have more than an undergraduate degree. I'd have to have a better, more education than the men. So that's when I decided I would go to law school.
That's interesting. Were there any lawyers in your family, or were
No,
there
none.
None. How did your parents feel about the idea of you going to law school?
They were pleased. My father was a parliamentarian. He taught parliamentary procedure, and my mother had at one time wanted to go to law school, but it was simply impossible during the Depression. She had to support her family, and so they were very supportive. And they didn't want ever to have their daughter caught in the problems of the Depression that they had been caught in without a proper education to be able to support herself. So they were great.
And you went to the University of Chicago. Mm-hmm. How did you come to choose Chicago?
Well, I went to Swarthmore College in part because they were recruiting geographically, and they wanted to have students from the Midwest, so they gave me a scholarship. And when I was applying to law school, the University of Chicago wanted to have students from Eastern colleges, and so they gave me a scholarship because I was from Swarthmore, and I received a scholarship that was earmarked for a Swarthmore student.
Were there many other women in your class?
No, there were 6 of us out of 150.
And did you study as a group, or did you study on your own?
No, we studied pretty much on our own. Most of us were in a dormitory. They called it a dormitory that had been set aside for women graduate students. It was in a very bad neighborhood. My roommate was a historian. We had a code because as we went through the year, my first year in law school, the university was tearing down all the buildings around the building that we lived in, about 100 women graduate students. So we became kind of a target. So we had a code of if you hear 3 knocks, open the door. If you hear only 2 knocks, call the police. And we were not really welcome. Women law students or graduate students at the time in any of the great universities, I don't think.
Are there any professors from law school whose classes stand out in your mind?
Well, my favorite professor was always Professor Meltzer, Bernard Meltzer, Bernie Meltzer. He was a wonderful man. His son is now the director of the American Law Institute and a very distinguished professor, Professor Daniel Meltzer at Harvard. But Bernie Meltzer liked people. He had been a prosecutor at Nuremberg. He was a labor law professor who brought labor cases into NLRB cases into the law school so that we could hear them. He was a very unusual person, and I liked him a lot. And he made a lasting impression on me, I think, as a role model of what lawyers can do to make things better.
Were any of your fellow students, the males, did they try to make things difficult for you?
Oh, the students didn't. Mm-hmm. The men's students, well, I married one of them, but we didn't really get together until the 3rd year. But so the students were nice, and they didn't resent having women. They thought we were kind of a novelty, and I enjoyed having all those men around, so that part was good. The professors did not want us, and they made things very difficult. They would, for example, in our property class, the women would be called on every other day, and the men would be called on once a quarter.
Interesting.
It all changed.
It has changed. It has changed. And you graduate from Chicago in 1965.
That's correct.
And you studied for the bar?
Yes, yeah.
And you
I went to Washington.
You went to Washington, and well, tell me about your experience in 1966 or 65 after graduating law school.
Well, the interesting experience was entering law school before Title VII was passed, and then graduating from law school after it was the law of the land that employers were not to discriminate against women and minorities. The employers didn't pay a lot of attention to that, but the United States government did, and President Johnson issued an executive order that all the federal agencies should start looking for women and minorities. Of course, there weren't any graduating from the law schools because they would have been very stupid like me to go to school before there was a law to protect their right to get a job. So there weren't very many, so I had my choice of the federal agencies. And I chose the Justice Department as the one that would give me the best chance to get litigation experience and to be something that could be used anywhere in the country that I wanted to work.
And who did you work under?
I worked in the section that was known as the Court of Claims section. It's now the Claims Court. But we handled all of the contract litigation against the government. And since it was the Vietnam War at that time was escalating, and so when I started, there was a rule that young lawyers with less than 2 years' experience couldn't handle a case that was worth more than $100,000. And by the time I left, I think it was up to about $2 million because the litigation just kept growing. So it was a great experience to be against good lawyers who were representing clients who had a lot at stake. It's the best kind of experience you can get in litigation. And there was excellent supervision in the Justice Department in terms of writing and making sure that our positions were all consistent.
Who was your supervisor at
The
Justice?
great man who was the head of the section's name was Irving Jaffe. He was a wonderful lawyer, and I appreciated his mentoring a lot.
Were there any other women in your section?
A few, 1 or 2 out of 50. They were good, though.
And you were married by this time?
I was married when I began at the Justice Department.
And presumably your husband came back to Washington with you?
Well, we both had jobs in Washington. It wasn't coincidental, but he clerked for a great judge on the D.C. Circuit, Carl McGowan. Our firstborn was going to be named Carl, but it was a girl, so she was called Caroline.
I see. I see. And how long did you stay at the Department of Justice?
Well, I stayed at the department until 1969. There was a changing of the guard of administrations after the 1968 election, and a new group came in. Many of them wound up in jail as a product of Watergate. But I didn't like the atmosphere in the Justice Department. My husband said he wanted to try teaching before he earned too much money at Sidley and Austin for us to afford to leave. And so we just picked up and left Washington and went to Arizona, where he took a job.
And was the law school just starting at that time?
The law school was just starting, and we were there to see the first graduating class of Arizona State University Law School.
Got in on the ground floor?
On the ground floor.
What was it like for you coming to Arizona at that time? Were you going to go into private practice if you could? Were you going to work for the government?
Well, my aim was to go into private practice, and I didn't do much research. I just wanted to leave Washington and go with my husband, and I wanted to live in the West because I had been born in Colorado, and I was anxious to get back to the West. So I didn't do a lot of research about what the job situation was like in Arizona, which is probably a good thing, because if I had known, I would never have come. So when I got there, I discovered that there were no women in any of the major firms. And I had the name of one contact who had been in my section at Justice. And he gave me a name in every law firm who I could call and use his name in order to see if they would interview me. And they all said they would be happy to talk to me because they'd never seen a woman before who had graduated from a national law school and who had Department of Justice credentials. In fact, they'd never seen a woman seriously to interview before. So I was a curiosity. And I interviewed in every firm, and they all told me that they couldn't possibly hire a woman because they'd have to change their kind of language that they used in the firm meetings, and the clients wouldn't like it, and they just couldn't do it. And but then finally one law firm called me back and said that Monroe McKay was his name. He was the hiring partner at Lewis and Roca. He called me back and said that there was a position at as a law clerk at the Supreme Court of Arizona. And since I couldn't practice law for 6 months because I had to run a residence, they were very down on people who moved to Arizona and wanted to practice law, so there was a 6-month residence requirement. Everyone had to take the whole bar, no reciprocity. So I went out and was a law clerk for a year for Justice Jesse Udall. Wonderful man.
What was that experience like? What did you do for the justice?
Well, it was great. I wrote opinions, and I talked to him about life. He was the uncle of Stuart Udall and Morris K. Udall. Morris K. Udall was the great man in Arizona, wonderful sense of humor, member of the House of Representatives, aspirations to become president. He should have been president. He would have been a great president. Wonderful environmental lawyer, the author of a treatise on Arizona evidence. And Jesse Udall, the judge I clerked for, loved Morris, and whenever we got into a disagreement, the judge would say, I think I'll talk to my nephew Morris about that. And then I knew that he would decide the case my way, because Morris K. would always agree with me and would always disagree with his uncle, and his uncle knew that very well before he talked to him. So it was a great experience, and I got to know the members of the Supreme Court, including Lorna Lockwood, who was the first woman ever to be the Chief Justice of a state Supreme Court. She became a mentor of mine and a good friend for many years. So that was the best thing that could have happened to me. And then I also learned about the firms in Arizona, because I saw the work that they did, learned who the good lawyers were and the bad lawyers. Great education, too.
Who were the good ones at that time?
Well, there were some great lawyers in Arizona at that time. The leading lawyers civilly were John Frank, of course, who became my mentor, who had clerked on the Supreme Court for Justice Black and taught at Yale for many years, and Rex Lee, whom I had known at the University of Chicago. And Rex was later became the Solicitor General of the United States, and then the founding dean of the Reuben Clark Law School at Brigham Young University. He was a great lawyer, very fine man, died of a very untimely death of cancer. And then the great criminal lawyer was a man named John Flynn, who was the best lawyer I've ever seen in my life. He could hold a jury in the palm of his hand. When he argued, or Rex Lee argued in the Arizona Supreme Court, or John Frank argued, when any of the three of them argued, the law clerks would, the offices all emptied out, and everybody would come into the courtroom to hear them argue. It was great. I don't think there was another place in the country where you could hear lawyers of that quality on a regular basis.
What a great experience.
It was wonderful.
So your clerkship ends after about a year, and you're on the job market again.
Well, I was recruited then by Lewis and Roca. It turned out that they had sent me out there to park me, and they had had a big blow up in the firm because they had wanted to hire a woman, and the woman had been blackballed by several of the partners who refused to permit a woman in the firm, so they changed the whole hiring system. Just as I arrived, they changed the hiring system so that they had a hiring committee and did away with the blackball system. I didn't know any of this, but then they recruited me to come down because they had the hiring committee in place, and they were going to decide, Monroe McKay and John Frank had decided that it was time to follow the law and to bring a woman into the practice. So they gave me a day of the toughest interviews I ever had in my life, and brought me into the firm. What happened though was that just the few days after I got the offer and was trying to mull over what I should do, I was feeling very unwell and thought that my mind was going, and that I was not up to the stress of it all. And my husband told me that before I saw a psychiatrist, I probably ought to see an obstetrician. So I did that and discovered I was 8 weeks pregnant, something like that. So I began my job at Lewis and Roca as the first woman pregnant, and was told by John Frank and Monroe McKay not to let anybody know that as long as I could, because there would be hell to pay if it was discovered too early that I was pregnant. So I was a little bit pregnant for 8 months.
What was it like? What sorts of cases? What sort of cases did you work on in those first few months?
I worked on everything that they gave me. I mean, I didn't. I just decided I would just, do the work as they assigned it to me. I spent I went up to Flagstaff on an injunction case involving mining up there, I think. I worked on licensing contractors, had a couple of hearings on that. I was as the youngest lawyer, I had to go to the courthouse every afternoon to do the filing, they called it in those days. You took the pieces of paper physically to the courthouse. And they wanted the newest lawyer always had to do that because it was a way of getting to know the secretaries to the judges. And by knowing the secretaries to the judges, you would be able always to get appointments with the judges and get in. It was quite a system. And so I did that and had defaults signed and that sort of thing. I just kept doing that. It was very hot. The baby was born in June, and I was still doing that in May in Arizona. But I just thought that I couldn't ask for special favors, so I just did it. It was good for me, actually.
Did the firm grant you maternity leave, ultimately?
No, it didn't. There was no such thing. The managing partner came in one day and asked me what I planned to do. And I hadn't really thought about it, but I had one of my few strokes of genius that I've ever had in my life. And I looked at him and I said, well, I thought I'd take about the same time off as the men are taking to do their ROTC or their military training because it was then Vietnam. And that was about 3 to 4 weeks, and he looked at me, the managing partner. It was the biggest sigh of relief I've ever seen in my life, and he said, "Well, that seems very fair." And he backed out of my office, grinning because he had the solution to the problem. Of course, I was only home for 2 weeks because I really didn't like. I love my children. I love my children. I enjoy them enormously, but I didn't do well with newborns, so. Mm-hmm. I was back in the office fairly soon.
When did you start to think about becoming a judge?
Well, I really didn't think about it very much because it wasn't something that a woman could do when I was in law school. It just wasn't a possibility. And then when I got to Arizona, there was... soon after I got there was an election in the state court in which a wonderful man by the name of Tom Tang, who later served on the Ninth Circuit Court of Appeals with great distinction, he was defeated in a contested election in Arizona because of an unpopular decision he had made involving a couple of juveniles that the newspaper thought he had been too lenient toward. So there was a big brouhaha soon after I came to Arizona, and Tom was defeated, but the business community was so angry at the idea that a good judge could be thrown out in a contested election that the business community, and I think Barry Goldwater and other responsible citizens of the time decided that they should institute merit selection, and they did. Arizona put in merit selection by referendum. It became effective about 1974. And at that point I started thinking that maybe a judgeship was possible. I would never have wanted to run in a contested election, but on that system I thought about it, and Lorna Lockwood called me and asked me to consider it because she was retiring and she didn't want to leave the appellate courts in Arizona without a woman. So, and John Frank encouraged me, so I applied through merit selection.
And what was that process like?
I don't remember very well. There was an interview and nominations, and I knew both there were 3 nominees, and I had a party for it. There was one Republican, one Hispanic, and a woman, and so I had a party. We were all friends, and so I had a party, and I called it 3 coins in the fountain party as the 3 tokens, and one of us was going to get the appointment, and I did, I think, because of the woman factor, and that the governor wanted to put a woman in that slot.
And you were appointed by Governor
in the Court of Appeals by Raul Castro.
Castro.
Mm-hmm. Who's still alive.
Oh, is he really?
Mhm,
Oh,
in
that's
the 90s.
interesting. That's interesting. So you sit on the Arizona Court of Appeals for about 4 years. What was that experience like?
Well, I enjoyed it very much. I had one of the reasons that I was interested in leaving the private practice was that I was getting to the point where I didn't have enough time to do any thinking on my own. I was delegating work to young associates, and I was not, and I was with clients, but I wasn't actually able to do the work that I would have liked to do, and as much briefing and memoranda writing as I wanted to do. So I thought it would be good to be on the Court of Appeals, and I really did enjoy it. I enjoyed the writing, and there was a very good group of people on the court at that time. And the Supreme Court was very supportive. The problem that I had, not a problem, but after I'd been there for not too long, I discovered that I was pregnant again, and so I had my second child, which prompted an interview with the newspaper because a friend of mine wanted to interview me. She was leaving the Arizona Republic and wanted me to be her last story. Because she was leaving and she was much beloved, they put the story on the front page rather than on the women's page and on the Sunday edition, and this created a brouhaha because everybody who read it apparently thought that I was taking the baby to the office because there was a picture of the baby with some books in the background. It was just our study, and I was very careful to say that I would take the baby to the office while I was reading, but anyway, they thought that there was a baby on the bench who was being nursed while I was presiding over trials. And so there was, Your Honor, I object letters to the Republic and all kinds of stuff. But we outlived that too. And it was, that was an experience too. But I thought, how can it be that the only things that I've ever done that have got me into trouble have been having babies?
Funny how perception becomes reality sometimes.
Right.
Another merit selection panel comes along about 1979.
Yes. After the election of Jimmy Carter
Right.
decided he would do merit selection. It was still, I think the expression was at the time, it's still best to know thy senator. But yeah, Jimmy Carter instituted merit selection, and there was an omnibus judgeship bill passed that created 10 new judgeships for the Ninth Circuit. So Carter transformed the Ninth Circuit by making it from a court of 12 to 25. I think Tom Tang and Proctor Hug were the first two appointments under Carter, and then the rest of us followed along.
And what was that process like? Did it differ much from the selection process in the Arizona Court of Appeals?
Well, it was. Yes, it was different. There was some hostility on the part of at least one of the members who didn't think that a woman with young children should be a federal judge. And because the Ninth Circuit is big and people have to travel, he asked me the question of whether I'd given thought to how much damage this would do to my family. And this caused one of the women on the panel to become quite annoyed and say, after the interview had finished, she sent me a note, said that she had become quite irate and asked him why he didn't ask that question to the man they had interviewed previously who had 8 children. But these things die hard. But it worked out, and Senator, by that time I had gotten to know Senator DeConcini, who was our Democratic senator, and he was quite comfortable with my appointment, so it worked.
You've had many cases on the Ninth Circuit.
Mm-hmm.
I suppose one of the more memorable ones is the Hirabayashi case.
Mm-hmm.
Would you like to talk about that a little bit?
Well, I've called the Hirabayashi case the opinion of a lifetime because it's judges on the Intermediate Court of Appeals don't often see a case that has as much historical background and current significance as the Hirabayashi case. Gordon Hirabayashi, of course, had been convicted of refusing to report for the internment and curfew of Japanese Americans during World War II. He was an American citizen born in Seattle, student at the University of Washington at the time. Didn't think it was right. Fought the case all the way to the United States Supreme Court and lost, along with Fred Korematsu a little later. And in the 80s, Peter Irons, a historian, dug up information that indicated that the Justice Department had lied to the Supreme Court and that they knew that there were no security risks among Japanese Americans and that this was all based on racist lies. And so Hirabayashi and Korematsu filed their cases for a writ of coram nobis in the 80s. With some very courageous lawyers, because this was not that long after World War II. Those who had fought the war against the Japanese were still on our court, active judges, and influential members of society, and this was not something that people readily accepted. But the case was argued. It was argued very well. I remember it was argued in Seattle. Hirabayashi was in the courtroom. Peter Irons was in the courtroom, and it's been written up in, Peter Irons wrote a book and described the argument. And then I worked really hard to write the opinion. Judge Goodwin was the presiding judge, and he didn't feel comfortable writing the opinion. And he assigned it to me. I thanked him many times for that. And Jerome Ferris was on the panel as well. And we worked hard and I think wrote a pretty good opinion. And the government then did not appeal it. So in the story of the Japanese internment, I got the last word, kind of, and that I thought that was good. And I just last week went to Seattle to speak at the 25th anniversary celebration of the Civil Liberties Act, which was the act passed the year after the Hirabayashi opinion that apologized to the Japanese Americans who had been interned and made reparations. They had a big celebration in Seattle, and I had my picture taken with the children of Yasui, Korematsu, and Hirabayashi. Actually, the nephew of Hirabayashi. But it was a very moving experience for me. And it's not long. It's not. Then there was a big celebration of the 25th anniversary of the Hirabayashi opinion too. So I've said many times that it's not often that a judge on a court like ours gets to right one of the great wrongs of history, and I got to do that along with my colleagues and some great lawyering, and a very courageous Gordon Hirabayashi, who became a good friend, and he was, despite his anger that the government never took the case back to the Supreme Court, he wanted to be vindicated by the United States Supreme Court, but the government didn't appeal it. Which I told him, that's just as well. Don't run after the train when you've caught it. So
that's a marvelous case and a marvelous end to a very sad time in American history, it seems to me.
Yes, we did the right thing in apologizing and recognizing that it had been such a wrong. But I think that's important, that we remember that those things can happen, and they can happen again.
Is there anything that I haven't asked you about today that you'd like to talk about?
Well, I would like to say, as far as my chief judgeship goes, that I think that our court and the judges of the Ninth Circuit fought off a very real threat to judicial independence that we have to we should not forget either, and that is that when courts make decisions that are unpopular, they create they can create storms of public opinion that are negative, and that's happened to our court historically several times, beginning with Indian fishing rights, timber cases where we said the spotted owl should be saved and alienated strong economic interests. And then when I was chief judge, the Pledge of Allegiance case that invalidated a California statute that required the teachers to lead under God before all the classes in the state. And there was a very angry uproar against that decision, and it all was aimed at our court. And the demands to divide it and to punish us were enormous and loud. And I think the symbol of it was a letter written to the Chronicle that in San Francisco that they published that said, "Kill all the judges of the Ninth Circuit." So I think that that era was difficult, and the judges of the circuit and the lawyers and the academics in the country rose up and saw that what was happening, and they all came to bat for us. And in the end, we had a definitive hearing in which all of our bankruptcy judges signed petitions, almost all of our circuit judges, the district judges, 500 academics, and all of the bar associations in the circuit that could take a stand did, and national bar associations, the ABA and the federal bar, wonderful. And that was a united front to fight off a threat to judicial independence. And I don't think we should forget that either. It was a very difficult time for our judges and for me personally. And I had to testify 5 times before hostile committees in Congress. But the threats to the independence of the judiciary go on. They're in different forms. Starvation sometimes. We don't get pay raises. We can't fund. We can't build buildings. And we are insulted. And it's just we have to be very vigilant. And the bar and the courts and academia, all branches of our profession, have to work together and stand up to those threats.
The split was the attempt to split the circuit was a very difficult time. And one of the recurring comments from critics of the Ninth Circuit is that it's too liberal. You see this in the newspaper all the time. How do you respond to that?
Well, in the first place, it's absolutely not true. And I don't know what too liberal means, but all of our judges were confirmed the same way that all the other judges in the country were confirmed. And that I think that cry of being too liberal is now way outdated. I think that was also a product of the reaction against environmental decisions of our court, the Pledge of Allegiance case, and a few others. And it turned out on almost all of those cases that we were right in the end. And if there is a perception on the part of Congress or the public that courts are out of whack, there's a political solution to that. It's that we're all appointed by the president, who was elected by the people, and members of Congress have a heavy hand in deciding who should be on the courts. So that works itself out too.
Well, I've really enjoyed chatting with you this afternoon. I appreciate you making the time out of your busy schedule to sit down with us.
Okay, thank you.
And I want to thank you again for participating in this project.
Okay, thanks for doing these histories. They're good things.
Thank you.
Thank you.